This is the latest as of today. Now, in this context, what do you make of the Constitutional Court ruling that the process was unconstitutional? Can an unconstitutional process give birth to a legitimate product?
Okay, thank you so much for that question. Let me give context to what the court said in the Mkandira case. To start with, the Constitutional Court did not declare the process to be unconstitutional. What the Constitutional Court said is that the process was against the spirit of Articles 2, Articles 61, Article 90, 91, and other articles. That is not to say that the process is unconstitutional. There is a difference. What the Constitutional Court, you can go in the judgment, read the judgment towards the end where it made some orders. It said it is against the spirit. So where is that spirit coming from? So according to the court, the spirit for constitutional making process in Zambia has been traditionally, you begin by going to the people, okay, with the proposals that these are the areas or we want to amend the constitution. So you go with those proposals to the people. Then after you gather the views from the people, you come up with a draft bill. That has been the tradition. So that is the spirit. Now, what spirit was the court talking about? The spirit the court was talking about is that when you look at the powers that creates the executive, the powers that creates the legislature, and the powers that creates the courts or the judiciary, you will discover that all the powers are derived from the people. So you look at Article 61, the power to legislate is derived from the people. You look at Article 91, the power, the executive power, is derived from the people of Zambia.
So in your view, what was the ruling of the Constitutional Court?
I'm coming there. Then when you look at Article 18, the power to the judicial power is derived from the people of Zambia. So that is the spirit the court is talking about. It is saying that all these organs of government, they derive their power from the people. If they derive the power from the people, you need to consult the people whenever you want to make a constitution. So the true judgment of the court is that the process that was taken was not did not garner a lot of consultation, wide consultation. So it is against that spirit that you did not go and consult the people.
So what was unconstitutional, the process or the Bill 7?
Bill 7 cannot be unconstitutional, and the court did not even talk about it.
Let me quote the summary of the conclusion of the court.
Not a problem.
The Constitution Amendment, this is a direct quote,
yes,
from the ruling.
Yes.
The Constitution...
What page?
I just extracted that.
No, it's very important to know the page. You know the reason why it's very important to know the code, because you need to know whether because there's...
Let me finish reading it,
not a
then
problem.
You can...
Not a problem.
The summary says, the Constitution amendment process cannot be initiated without the participation of the people of Zambia through wide consultations. We come to the inescapable conclusion that the process is unconstitutional. That's the Concord ruling.
Now go to the conclusion of the court, where the judgment is and the orders of the court. Just go down that same judgment.
As I said, I only extracted that because you were saying, so in your view, neither the process nor the product was ruled unconstitutional.
No.
So what was the verdict of the court?
So when you want to understand the verdict of the court, you go to the last page.
Yes, what did it say?
Yes. So what the court said is that it made certain orders. One of the orders is that the process was against the spirit. You just go to towards the end. Was against the spirit of certain provisions of the Constitution. And in saying that, it doesn't mean that it is unconstitutional. Remember, the power to amend the Constitution or to make any law.
Did,
It's
you are on TV.
Yes.
And you are an officer of the court.
yes.
Did the Constitutional Court say go ahead with Bill 7? Let it be debated before the House? What?
That's
I want you to be very clear.
okay. Let's see. Let's read.
Not to skate about
Let's read
this matter.
Let's read. Do you have the judgment there? Just read the conclusion to the judgment.
I'll pull it out as we discuss.
Yes. When you look at the conclusion to the judgment, it's important to make those pronouncements here and then, because we should not wait until we go into this discussion misled.
Exactly.
Because there are a lot of misleading statements that have been made where they are saying no, the court judged.
I think give the people of Zambia a summary of your understanding of the Concord ruling.
So my understanding of the Constitutional Court ruling is that the process leading to the formulation of Bill 7 was against the spirit of certain articles of the Constitution, such as Article 60, I think one of them is Article 60, Article 5, Article 2, those, against the spirit. So remember.
If you go against the spirit and
yes,
you have abrogated provisions of the Constitution, are you within the Constitution?
You're within the Constitution, because remember, the spirit is an interpretation of the court. What the court thinks. Remember, Article 79 is complete in itself. It's very complete in itself and authoritative on anything to do with the amendments of the Constitution. So what does Article 79 say? Article 79 says that if you want to amend the Constitution, you understand, it will not tell you that you should go to the people. Article 79 vests the power to amend the Constitution to Parliament. So Parliament can amend the Constitution. Remember, the Constitution...
Without the participation of the people?
Just wait, I explain Article 79. Article 79 creates two instances. What are those instances? It recognizes the fact that, one, there are certain provisions in the Constitution of Zambia that are called entrenched provisions. And there are provisions in the Constitution of Zambia that are not entrenched. Now, which provisions in the Constitution, which provisions in the Constitution, which we are going to say that are entrenched? Article 79 itself and the Bill of Rights. For you to amend the Bill of Rights or to amend Article 79 itself, you need to go to the people. That's what the law says.
Which Bill 7 didn't.
Just wait. Bill 7 does not touch Article 79.
No, I want us to...
Very clear. Bill 7, let me finish so that you can have a clear picture of what Article 79 is doing. So Article 79 creates that scenario. You want to amend the Bill of Rights, you want to amend Article 79 itself, you need to go for a referendum. There it is mandatory to go to the people, for the people to vote yes or no to the amendments. You understand? Then we have what are called the provisions in the Constitution. Any other provision other than Article 79 and the Bill of Rights, those are not entrenched provisions. Article 79 does not give a directory that you should go to the people. So when the court was interpreting Article 79, it looked at the spirit of Article 60, Article 90, and Article 118. So according to Article 1, and these are traditional things, it says it has been customary for whenever you're amending the Constitution to go to the people. Otherwise, in itself, Article 79 gives you direction on how you can alter the Constitution of Zambia. It does not tell you to go to the people when you want to amend provisions of the Constitution that are called, which are not entrenched.
Let's leave it at that. President Hakainde Hichilema called for dialogue recently, which has since failed. Both government issued a press statement through the chief government spokesperson that it had called for, it had, discontinued the dialogue, and also Oasis Forum did hold a press conference and issued a video in which they announced that they had equally disengaged in this dialogue. In your view, from where you are standing, what do you think led to this standoff?
In my humble opinion, you see, when you are going to a dialogue table, you need to be honest, open, and you should not go with a stagnant position or a position that should not change. You understand? On the position of government, they were ready to dialogue, open to suggestions on how best we can amend this constitution and make it better. You understand? Whereas our colleagues from the Oasis Forum, they went with one position, withdraw. That's all. Now, when you go, you know, whenever you are going to a negotiation or to a dialogue, because remember, the president is a very busy person in this country. From his schedule, he made time for that dialogue. Then you go with only one position, let's withdraw. It would have been better if they had alternatives on how best this process can be done.
But they raised the concerns as to why they were suggesting a withdrawal and an alternative route to say we need to include the Bill of Rights. We can't just amend the constitution to focus on political issues and forget about the Bill of Rights. That was their suggestion.
The Bill of Rights is a political issue. It is a political issue.
It's a human rights issue.
It is actually a human being. A human being is a political animal.
Now, so let's talk about the Bill of Rights.
So when you're talking about the Bill of Rights, you're talking about a human being.
This is not about suspending how an election is conducted. This is not talking about how a mayor, what's the term of a mayor. That's not human rights. That's politics. Bill of Rights talks about you and how you ought to be taken care of and how you ought to live. It's you as a citizen. And that's what they are saying. Why are we focusing on politics and not focusing on what is affecting the everyday lifestyle and living of the citizens? So they came suggesting that we recognize the need for constitutional amendment. Okay. But I remember them saying, let it be holistic.
You see, when these processes were begun by government, we were told that it will be done in stages. And one of the stages is that which is going to look at the amendment of Part 3 to include economic, social, and cultural rights. What is government doing to enhance those rights today? This is what government is doing. So this government is proposing that we should delimit the constituencies. Why? So that more resources can go to the constituencies. Once more resources go to the constituencies, what are we going to have? We are going to have better schools in the constituencies. We are going to have clinics in the constituencies. We are going to have good water articulation in the constituencies. This answers now to the rights that you want to enforce once it is part of the Bill of Rights. So what this government is doing is that before we can amend the Bill of Rights, let's first put things in order. You understand? Before you even go to a table, put your house in order. So what the government is doing is that let's delimit the constituencies. Once the constituencies are delimited, we are going to have good schools. Just wait. We're going to have good schools. We're going to have good health facilities. We're going to have clean water, so that the time we amend the Bill of Rights, even if you take government to court, government is going to say, we've done this, we are doing this, we are doing this.
I wish you were a minister, but you are a lawyer. I was going to ask you that, what's the quantum of CDF today?
What do you mean by quantum?
How much is allocated to a constituency today?
At the moment, it should be, I can tell you I think it's 31.6 at the moment. But for 2014, For 2026, it's going to be 40 million.
So what would prevent you, from building a school or a hospital or a road or whatever? Because you're saying you have to delimitate to deliver a school. That money today, isn't it still doing the schools you're talking about? And
so this is how it is. You see, it's very important to understand how delimitation has a consequence on proper service delivery. This is how it is going to be. We have constituencies which are very big in this country, such as Kanchibia, Shiwangandu.
But the population is small. Let's be very honest.
What is the population for Shiwangandu? For you to say that it's very small.
Can I tell you something?
No, I'm just asking you, because you can't say that the population is very small without you knowing the population for Shiwangandu. What is the population for Shiwangandu?
Let me give you Lusaka.
No, I'm asking. No, we are not going to use Lusaka.
No, we have to use Lusaka.
Let's use Shiwangandu, Kanchibia.
No, let's
drive a point.
Yes. I know for a fact that Kanchibia or Shiwangandu, the population density there cannot be compared to the population density of Lusaka.
Lusaka is not a constituency. Lusaka is a province and a district.
Okay, let's
talk about constituencies.
Let's pick Kanyama, for instance, as a constituency.
Yes.
Or Mandevu as a constituency.
Yes.
The people in Mandevu would probably be more than the people in Kanchibia. It's a village. So you understand? So,
granted, the population, when you're looking at delimitation, you are not just looking at population size. You are looking at population size as well as geography. So now, you find that in villages, people are concentrated on one area or in patches of areas. So when you do delimitation, you look at two issues, the population and the geographical size. So in terms of geographical size, we have constituencies that are too vast. Like, for example, Kanchibia, Shiwangandu. If those, at the moment, if, for example, we are now in 2026, we were to divide Shiwangandu into two, it means that the old Shiwangandu will have 80 million injected into two constituencies. So we are going to have 40-40 instead of just them having 40 million. So that 40 million, one, if Shiwangandu today was delimited, it would mean that the people of Shiwangandu are going to have better service delivery, because the resources are going to be more. Instead of them being shared on a bigger constituency, they're going to be shared on a smaller constituency. That in itself fosters development to the people.
Well noted. I wish we can spend more time on this, because I'll tell you that even with 30 million, very few constituencies have even unlocked that resource. So the very fact that it's been pronounced doesn't mean you're going to see development.
Yeah.
So it's one thing that would be debatable. It brings me back to my question. So you reckon only because Oasis Forum came with a fixed position, that's why the dialogue failed, even before they could engage and discuss?
Are you aware that even when they went for the second discussion, they already had a letter written?
Because if you're engaging...
So then why are you engaging when you already have a letter?
That's the basis. You are stipulating these are the terms for our engagement.
In your view, who was more sincere in the dialogue? The government or the Oasis Forum?
No,
I'm just asking.
Dialogue never happened. What wouldn't it have been good that even in mediation, one party brings issues to the table, the other party brings issues to the table? What was wrong with the government also saying, okay, this is what we've read your letter and your demands, here are our demands, then now let's sit down, because you have what to look at from both ends?
But who tells you that the dialogue never ensued? There was dialogue. They went there, they started talking about the president having made a lot of promises which haven't fulfilled. Was that the reason why they were at State House? The reason why they were at State House was to talk about the constitutional making process. They divert their attention to start talking about the promises. Even then, why should you talk about only promises? What about those things that he never promised, but he has done? Why don't you talk about them? Like, for example, CDF. Did he promise that he was going to bring CDF at 40 million? No, but he has done it. Why can't you talk about it? So we should not be talking about negatives all the time. And we should also realize that promises sometimes are a mere puff. Okay? We should realize that promises can be made, but there are more important things to do. And I'm sure he has prioritized the more important things to do. So why should we be talking about, oh no, you promised that you are going to have fuel at 10 kwacha? See, when was that promise made? Was it made in 2021? That promise was made in 2016, 2015. What was the price market?
No. I think if we're going to talk about promises, let's talk about the promises for 2021.
Tell me one promise.
On fuel.
Did he make any promise in 2021? Show me the evidence. Give us the evidence.
Let me tell you. I can show
in 2021.
Even if you went to his page, it's there. He said
2021.
He said the PF are stealing. They are selling you 17 kwacha per liter because 3 kwacha goes to middlemen. We are coming to remove the middlemen and you'll be buying fuel at less than 3 kwacha, which is... That is very true.
Pastor, is that a promise?
It was
or is a statement?
No, it was a promise.
To say that you are stealing, is that a promise or a statement?
Said,
no, I just want you to answer my question. Yes.
He promised to come and remove the middlemen that were pushing the cost of fuel to 17 kwacha so that it can come to 12 kwacha. That was a promise. Just like the government and president promised the bag of fuel in 2021 that it would be 50 kwacha. That was a promise.
That promise was made in 2021?
Yes.
Show evidence. Show evidence that it was made in 2021.
I'll ask my director.
That's where the problem
I'll
is.
Ask my
we speculate
director.
a lot.
Oh, no. I'll ask my director.
No problem.
As we are discussing, pull out President Hakainde Hichilema tweets and all of those things where he was talking about meal price and fuel price. We will show it because you are challenging me. We will show it on screen.
We'll be very happy. And also show the context around because everything that is said...
No, but you cannot deny what is in the public domain.
Show that evidence.
All right, fine.
Yes.
We will show that.
Anyway, we are here to talk about the constitutional amendment.
Yes.
So, the constitutional amendment, this process, there is no illegality. That's it. There is no illegality, both in the process and Bill 7. So, what the Constitutional Court directed the executive is that you need to have a resemblance of a commission or a technical committee. What did the president do? He went and formed a technical committee. On what basis did he select a technical committee? He used the executive powers. Article 91, I think it's Article 91(2)(e). So when you look at Article 91(2)(e).
But he was supposed to appoint, again constitutionally, it's the Inquiries Act.
Who tells you that the Constitution can be amended by only the Inquiries Act? Actually, you should realize that the Inquiries Act, first and foremost, the Constitution of Zambia, Article 1(1), will tell you that this Constitution is the supreme law of the land. So which provision is supreme? Article 91(2) or the provision in the Inquiries Act, which is an act of parliament? It is Article 91. Is it the first time that a president has used the executive powers to amend the Constitution? It is not the first time. The first time it was done by Anyo Sulungwe. When President Sata appointed, the late President Sata appointed the Anyo Sulungwe Technical Committee using Article 34, which was the then executive powers. So those executive powers are vast. And those are the same executive powers that today the President of the Republic of Zambia, Mr. Hakainde Hichilema, has used to appoint the technical committee. Where is the legality there?
So
nothing.
Let's talk about the appointing of the technical committee.
Yes.
What was the essence of appointing a technical committee?
So the essence of the technical committee is twofold. First and foremost, it was a directive from the judgment that we keep on talking about, which a lot of people have not read and understood. So it was a directive that we needed, before Bill 7 or before a bill, a constitutional amendment bill goes before the bill is tabled, okay, it's supposed to have some views of the people, wide views of the people. So what did the president do? He conformed as a law-abiding citizen. And he appointed the technical committee via his executive powers. After he appointed the technical committee via the executive powers, they went and gathered views. They used physical submissions as well as the online submissions. It's the first time that the online submissions were given to a technical committee. And after those views, a report was given to the president, together with a draft bill. A draft bill. This material, the technical committee and the draft bill, now becomes a source of review in the parliamentary select committee at parliament. So again, the people of Zambia still have an opportunity to...
What is the essence of having two bills? You are saying the Mushawarati Technical Committee has produced a bill and the report they presented to
so we do not...
Wait a minute.
Yes.
They presented a bill, a draft bill, and a draft report to the president.
Yes.
All right?
Yes.
Then the essence was that is what was going to be sent to Parliament. Why is it that the government has suddenly backpedaled and said we are reviving the deferred Bill 7 in its original form? Why spend money on a technical committee? You said the essence was to go and gather and formulate a bill. Why gather all this effort, draft a bill, present to the president, and then you say we are going to revive Bill 7? Is that not a waste of time and money?
I do not think it's a waste of time and money, because the draft bill as well as the report will still be used in the parliamentary select committee.
I do not. You are a lawyer.
Yes, I'm a lawyer.
You are a lawyer.
So I wanted to correct certain things.
And I'm sure you understand also the rules of the House.
Yes.
Standing order.
Yes.
You know that you cannot present two bills on the same topic.
Has the government presented two bills in the House?
You've just
the answer is no.
You have just
said select committee.
It's still Parliament.
Listen. There is a bill. Bill 7 is on the table of the House.
Yes, but you want
the report. Just wait. That's the reason why we live with a lot of misleading statements, because we don't listen to each other. So the bill that is before Parliament, or that is tabled in Parliament, according to Article 79, is Bill 7. The technical report, as well as its draft, will be presented...
Draft bill.
Yes. The technical committee is going to present that draft bill and the report to the select committee to scrutinize Bill 7. So that bill and the technical committee submission, the original submissions the raw submissions are going to be used to scrutinize or to look at Bill 7. So that is the essence.
I need for you to be clear to the viewers here.
Yes.
You are saying there is only Bill 7.
There's only Bill 7 on the table of Parliament.
The other bill will be for source material, but it will be in Parliament.
Yes, but
and it's against standing orders. You cannot have two bills speaking to the same issue.
That's where the problem is.
That's not a problem.
Listen, for a bill to be presented in Parliament or to be tabled, okay, let's just use technical terms. For a bill to be tabled in Parliament, it has to be gazetted 30 days before it is tabled in Parliament.
Yes.
Has the draft bill been gazetted? The answer is no.
Yeah. Is this now an afterthought by the government that they've run out of time so they cannot gazette a bill? Because what is the essence? Tell the Zambian people. Wait. What is the essence of drafting a bill which you know you will not publish in the Gazette? And it will never become law Why do you go to that length of spending money, human resource to drafting a bill? Is not an easy thing, and the reason you have to draft a bill is so that it can become law. But are you telling us now that this is an afterthought by the government? They've realized.
How can it be an afterthought? How can it be an afterthought? In 2016, when we had the constitutional amendments of 2016, do you know that there was a constitutional bill, a draft constitutional bill, that was presented to Parliament, to the Select Committee? Was that a waste of money? No, I'm just asking you. Was that a waste of money?
I need to understand. Are you talking about, do you know that to do a constitutional reform, you need an act of Parliament, the legal safeguard that provides, guidance in how you do. The bill 10 you are talking about had an act of Parliament, a legal safeguard that stipulated how this was going to be done. All right? Is that the bill you're talking about? Because Bill 7 doesn't even have an act of Parliament.
There's no act of Parliament for Bill 7, but there's a provision in the Constitution that supports Bill 7, Article 79. That is the provision. Why do you need an inferior act?
So why do you need another bill to support Bill 7?
We are not saying that we need another bill. We are saying it's a source of material to mirror the views of the people. Listen, you have a document that is tabled before Parliament. You understand? You want this document, you want to scrutinize this document. So you look at different sources of material. And one of the sources of material to look at this document that is before Parliament is the draft bill, the draft report. So what I'm trying to say is that the technical committee report as well as the draft bill serves a very important role, as it is going to be an important source to scrutinize Bill 7.
Okay.
So there is no money that has been wasted, so to say.
Okay.
And there are no two bills in Parliament. There is only one bill, Bill 7. The bill that was gazetted via Article 79, because we are following the dictates of Article 79. There were the safeguards that are provided for in Article 79.
Right. Now, many people have written, I was reading earlier an article by Professor Lumina. He published it today. And he says the UPND has created a constitutional crisis. I want to just perhaps read something from there, a few lines, and then I need to get your reaction, because he says here in his conclusion, the country now stands at the edge of a constitutional rupture engineered entirely by those entrusted to safeguard the constitutional order. This crisis arises from the legal ambiguity, but arises not from the legal ambiguity, but from the executive's refusal to accept the consequences of its own unlawful actions. Bill 7, nullified by the Munir judgment, cannot be revived through insistence or political will. It cannot be revived. Okay? What makes this moment especially troubling is that government's decision to discard the very mechanism it created, which is the Mushavati, to repair the process. After directing the technical committee to produce draft amendments and a comprehensive evaluative report, the executive has ignored these deliverables, treating them not as tools of constitutional repair, but as obstacles to be circumvented simply because their content does not favor its narrow partisan interests. Meanwhile, the standing orders, this is where I wanted to go. Meanwhile, the standing orders leave no lawful pathway forward. A lapsed bill cannot be revived. A bill on the same subject cannot be reintroduced in the same session of Parliament. a fundamentally altered bill must be gazetted anew. By refusing to accept these constraints, the executive risks drawing Parliament into an illegality. So here is a professor of law arguing that Bill 7 has brought about a constitutional crisis and Parliament has been drawn into this illegality. A bill that has lapsed, as Bill 7 is lapsing on the 25th of December, cannot be revived. And if you are going to alter Bill 7 because you are saying that is going to be raw material from the Mshavati report and draft, the standing order of Parliament says an altered bill has to be regazetted. And it's being altered. Bill 7 is being altered. So it still means it has to be regazetted.
How has Bill 7 been altered?
You are bringing in matters that came from the Mshavati. They were not originally in Bill 7.
Have you seen anything that has been put in Bill 7 that came from the Mshavati?
Why is
No, I'm just asking you. It's a yes or no.
Why is
Sorry, sir.
Wait.
It's a yes or no.
No.
Let's move.
Wait a minute. Have you seen it?
Just like he's speculating. He's speculating that it has been altered.
You said yourself.
Let's start with my question. Yes or no? Have you seen anything from the Mshavati Technical Committee draft which has altered Bill 7? Yes or no? No, just answer that question. Just answer that question. It's a yes or no. Have you seen anything?
The government has not published.
You're not answering my question. My question is very simple. Have you seen anything in Bill 7 that has been altered by the Mshavati?
Let me take you back to your own submission.
No, it's just a yes or no.
No.
Then so that I can give you an insight of what the professor was saying.
I can tell you your own submission here. You said, this is what you said. You said the Mshavati report and the draft report from the Mshavati will be material by the technical.
Is it to alter the bill?
You said it has to be infused. That's what you said.
I never said that. Those are your words.
Why are they?
What I said is that you can still make submissions. Just like any other citizen can make submission, the technical committee is going to make submission and it's going to table the report.
Are you vacating your earlier position that the Mshavati report and draft?
You seem to have a very good misunderstanding of what people say. That's
No.
Because let me just explain to you what I meant, so that you should not go and
No, you are explaining to the people.
Yes.
I'm asking on behalf of the people.
Yes. So what is going to happen? Parliament has appointed a select committee, a parliamentary select committee. So that parliamentary select committee will still take views from the people, including you and myself. NGOCC can still go and take the views. Those views, together with the Mshavati Technical Committee report and the draft, will be used now to scrutinize the bill. To scrutinize the bill. That does not mean that the bill will be altered or the bill is altered.
So if the bill will not be altered significantly.
So I'm answering Professor. So that does not mean that you are altering the bill and the bill now needs to be regazetted. So what Professor is doing is that he has a misunderstanding, first and foremost, of the constitutional judgment that was passed. To start with, the constitutional judgment, the Constitutional Court did not say that Bill 7 is unconstitutional. Why did it say that? It said it is not. You can read that judgment.
The process was unconstitutional.
The Bill 7 is not unconstitutional. So to start with, the professor is saying that Bill 7 is a nullity. Bill 7 is not a nullity. It has not been declared as such. So go and read page 7 of that judgment. The Constitutional Court is saying we have no power to interrogate a bill, as that is the mandate of Parliament. The only power the Constitutional Court has is to review the process leading to the bill, and after the bill is enacted into law. So, by so saying, Bill 7 is not a nullity. Has Bill 7 followed all the safeguards that Article 79 has provided? The answer is yes. Has it been gazetted? The answer is yes. So that is the bill that is before Parliament, Bill 7.
Here is you challenged me to call the ruling.
Yes.
And the ruling here says, accordingly, we grant, maybe is that where it starts from?
No, I'm talking about, first let's start from the part where I'm saying, page 7, where the court is saying, we have no power to interrogate Bill 7.
Yes,
if it has no power to interrogate Bill 7, it cannot declare Bill 7 unconstitutional.
So let me just read this last part.
Yes.
Accordingly, we grant the following relief.
Good, correct.
We declare that the decision by the respondent to initiate a constitution amendment process before undertaking wide consultations with the people goes against the spirit of Articles 1, 2, 5, 7, 8, 9, 61, 90, 91, and 92.
Just stop there.
Of the Constitution.
Yes.
We order that the respondent complies with the spirit of the Constitution by ensuring a people-driven process led by an independent body of experts in conducting wide consultations with the people.
Remember what I told you? I told you that the Constitutional Court did not declare the process unconstitutional. What the Constitutional Court has said is that it is against the spirit.
So when you are against the spirit, what is that?
So that against the spirit does not mean, it does not offend. You know, when you say that something is unconstitutional, it means
so it offended.
Article, it never offended.
No, it is against.
No, it never offended. Listen, the spirit, you see, the spirit is an interpretation of court. It is not there in the Constitution. You understand? So there is no provision in the Constitution that that process has violated. It's very important.
So how did you understand the Constitutional Court ruling?
So the Constitutional Court ruling is very simple. What the Constitutional Court is saying that if you read the whole judgment from page 1 to last, you understand that the Constitutional Court even went to the history of our Constitution.
No.
Just wait.
What did the
so that I go now to the ruling. So it went round, spoke about how constitutional reviews have been done in the country, where people were consulted, the views were collected, and everything like that. So it said this spirit, remember, this spirit is not in the Constitution. You understand? That spirit, the interpretation of that spirit is not. So it
meant they went against
the spirit or the tradition or the custom.
The process.
The custom.
There
has been a custom.
Yes.
Remember,
so
customs, you have a statute as well as a customary law. Customary law is just a custom. It's not codified. You understand?
Let's
so do you see now why?
Let's simplify it.
Yes. You asked me a question. Let me finish. So it never. So first thing, it never said that the process was unconstitutional. Granted. Secondly, it directed the executive, and when it directed the executive went and appointed a technical committee, and the Mshawati technical committee was appointed. It has brought a report and its draft bill.
So why do you?
So it has complied.
So why do you revive Bill 7, which lacked the spirit of the Constitution? Why do you want to bring the Mshawati, which has complied with the spirit, as you are saying, and you want to marry it with?
The spirit of the Constitution is not something that is codified. The law that gives government the power, the parliament, the power to amend the law is Article 75, codified. Between articles, that's the reason why the Attorney General today is saying we need to vacate that judgment. Because in essence, what the court was doing, it was amending Article 79 to include a stage that Article 79 has not looked at. You understand?
It will be interesting to hear the arguments from the contempt hearing tomorrow.
Yes.
It will be very interesting. But let's move on. The UPND rejected the bill number 10.
Yes.
For so many reasons.
Yes. And I'll give you those reasons.
Why do you think Bill 7 was not a necessity. Bill 10 was not a necessity. Bill 7 is now a necessity.
So, you see, that's why we always say there's context to every conversation. What was the conversation around the constitutional making process in 2021? We had a regime that had already defaulted in terms of paying the loan. Yet, this regime wanted to reintroduce deputy ministers via Bill 10. This regime wanted to have a bloated cabinet. Okay? So, according to Bill 10, one of the proposals in Bill 10 were that a cabinet meeting should have cabinet ministers, provincial ministers, chief whip, and the attorney general.
So
now look when you look. So you are looking at an expanded cabinet that is going to have a number of allowances. We objected to that. We objected to deputy ministers.
So hold on there. In the same context,
yes,
you think today Bill 7 and constitutional making process is more urgent than sorting out load shedding, than sorting out farmers who have not been paid? Because it's resources. Money, Mushavati went around, money was found. Farmers have not been paid. I am just giving you the same context you are using to argue why you rejected Bill 7. Why must Bill 10? Why must Bill 10 be such an evil that today we only have 2 hours of power? 2 hours, 3 hours. We spend money on a constitutional. We are more in an economic crisis than a constitutional crisis. So why would you want the nation to support a constitution when the UPND won the election with a landslide on a constitution that they want to change today? What has gone wrong?
Do you know that one of the promises that UPND made was that it was going to embark on what is called major reforms? One of the major reforms was to fine-tune this constitution. This
can fine-tune after they sort out load shedding, pay the farmers.
Wait. You've asked me a question, I'm answering. Again, you are asking the same question.
The reason I'm asking you
yes.
is because you gave the context to the Zambian people why Bill 10 was ill-timed because of the envelope.
I did not say that it was ill-timed.
Yeah.
All I'm just saying is that it had provisions that were going to be costly on the nation.
Ill-timed because you said the country had defaulted and the money was going to be reallocated to a bloated...
Now look at the situation that we are in. We are in schedule in terms of paying our loans.
No, forget about
No. It's very important. Why should we forget about that?
This is rain season. Farmers
and
have not
for
been
farmers,
paid.
For farmers.
The FRA has not paid.
No, just
Why
wait.
Are we spending
just wait.
Money on a constitutional making
just
process?
Wait. The first maize that was bought by farmers. Sorry, that was bought by FRA from farmers. Are you aware that it was paid? It is the extra maize that the government said through a cabinet approval that this maize that is languishing with the farmers, we should also pay, we should also buy it. And the government is doing everything possible to pay those farmers. It has already taken the steps. You are talking about load shedding. The government today is actively taking steps to reduce load shedding. We cannot, where you are seated there, we cannot solely blame the government for load shedding.
We are talking about priorities. Constitution making.
Is the government not looking? I'm just asking you a question. Is the government not paying attention to load shedding? It is paying attention. Actually, it has even gone further to say that this load shedding.
Is it a priority?
So
constitution making.
The government, it is a priority. We cannot enter into the next election with the way this constitution is.
Why? Is the world coming to an end?
The world is not coming to an end.
Yes. So why would you say what's going to happen if we enter?
We can have what is called a constitutional crisis.
How?
Remember.
How?
We are told that every 10 years, okay? Every 10 years, you need the ECZ is mandated to review constituencies, wards, the boundaries of constituencies, wards. Now, in the event that the ECZ discovers that actually we need to divide or we need to delimit these constituencies, it means that in essence will increase the number of what? Of MPs. For you to increase the number of MPs, you need to amend the constitution.
Do you have money for the new MPs? You have to take into account all these considerations.
This government, that's why we tell you that this government is a very good government. It does not embark on any process where it has not budgeted. Every step this government makes, it budgets.
So you are telling me you already know how many MPs we are going to have? You already know the delimitation report? The bill, even you ought to know. You are a journalist, you ought to know that tell the proposal. Tell the Zambian people what the delimitation report says. How many constituencies are we going to have?
No, you said...
You are challenging me to be a journalist.
Yes.
You may have information more than me.
Thank you.
So how many new constituencies under the delimitation regime are we going to have?
So there will be an increase of 55. Currently, we have 156. And they are going to have 155. It's there in Bill 7.
And do you know where?
So it's very important you read Bill 7.
Do you know where those
constituencies? I don't know where those constituencies. I do not know.
Why not?
I do not know. But what I know is what is in the public domain. What is in the public domain is that 55 seats.
Don't you think that's a problem?
No. So was I in government? Or am I in government right now? No. But the truth is that the report was given to the late president.
The president?
Yes, it was given.
Not to the country.
So, as journalists, you should have pressed it on that same president that you know the report. Why did you hide? But you let it be.
Do you know that people, journalists, politicians have written to ECZ for that document to be made public? It's not been published. Why? It's not a secret.
My pastor, you see, you have today. Just wait. You have what is called the information. What is it called? The one that you can go to any.
It doesn't work.
No, I'm just asking you.
Information. Access to information.
Access to information
does not work.
No. Try it.
No.
Try it. Has anyone ever tried it? Try it on this on the report.
It's never been actualized.
Listen, actually, what I'm going to do is that I'll give you free legal service. We try it.
No.
So that we can come today and tell people that no, we failed.
I don't need it. I can tell you, Sean Tembo went to ECZ to say, give us the declaration of assets, using the same act. They refuse that. It's not actionable right now, even as we are still.
Who amended that law? Is it the current president or the late president?
What do you mean?
There was a law that mandated ECZ to publish the asset, the declaration assets.
You are talking.
Just wait.
You are talking about access to information.
No, we are talking. First, wait. Yeah, we had a law that mandated ECZ to publish assets, declaration assets for the president. Yeah. When we reached 2016. After the 2016 election, that law was amended. You understand? So now ECZ is not mandated.
Yeah, but
so if you can use that Access to Information Act,
you are here.
You can still go there and get the information you want.
You are here telling the people or me to go and access the delimitation report using Access to Information. I'm telling you that Access to Information Act today, no one can use it because it has not been implemented. Are you aware?
What do you mean it has not been implemented?
Are you aware?
You can still go to court and get that information.
Well, let's move on.
The problem is we speculate, just like the professor was speculating.
We are not speculating. Only Access to Information. I dare you tomorrow, go and use it.
Actually, I can give you free legal services.
I do
so that we can go to ECZ.
I do not.
We can sue ECZ and get that information.
I do not need the free legal, I can pay for it.
Okay. No, I'll be very happy if you paid.
So let's talk about on Tuesday.
Yes.
Okay, we talked about the second speaker saying Bill 7 is coming back, and you have made some, clarity to the effect that actually what's being debated or what will be considered is Bill 7, not the Mshavati, because I wanted the Zambian people to know what is on the floor of the House, and I think you ably addressed that it is Bill 7. Now, let's go back to the earlier issue that we discussed. You are a lawyer, an officer of the court. What happens when one goes against a court ruling?
So, when one goes against, this is a general.
Yes.
You've asked a general question,
Yes.
I'll answer it generally.
Yes.
So, when one goes against the court ruling, it depends. Was there an order in that ruling? If one goes against the order of court, that is contempt of court, contemptuous. Okay? Now, in terms of the contempt of court that our brother, Celestine Mukandira.
No, it's Makebi, actually.
Yeah, but it's Makebi Zulu using, because they are just representing our brother. You understand? So the litigant there is not Makebi Zulu. Makebi Zulu is just a lawyer representing the litigant.
Right.
So the one who has taken the matter to court is not Makebi Zulu, it's the litigant through their lawyer.
Right.
Yes. So the contempt of court that our brother has taken to court has got no legal basis. Actually, it even shows that he does not understand his own judgment. You see, the court itself has said we cannot interrogate a bill. And what Parliament is going to do is to interrogate the bill that is before the House, which is Bill 7. How is that against the court order? What order has Parliament breached at that particular point? When you look at those orders, that the directives and orders that the government, so the Constitutional Court made in that ruling, there is none of them that he can say that you said this and they've done this. There's nothing. So for me, I find his action to just be a political gimmick of playing politics in court, which we should frown against. We should not, as officers of the court, because he's also an officer of the court, to be playing politics in court all the time. Look at how many suits he's been taking. I think it is high time that the Constitutional Court also should start punishing such litigants by making them pay costs for wasting time. Is there any merit? You've read those orders that the court has made. Have you seen anywhere where the court is saying we order that Parliament should not go ahead and interrogate Bill 7? It is not their mandate. It is not their mandate. Go to that judgment, page 7. The court will tell you that we do not have power to interrogate a bill.
So let's move on. I'll be picking up a few phone calls before we wrap up. But let's move on. Parliament or National Assembly will be going on recess on the 12th, which is in 8 days from now.
Yes.
You are saying the committee will be inviting people to make submissions. What time is there between today, the 4th, and the 12th? And now there is even a court matter. You said we cannot go into an election without making this constitutional amendment. And as I'm asking this question, I want you to have in mind this, that this Bill 7 that is being resuscitated lapses technically on the 25th from the date it was deferred of this month. If it lapses, it cannot be revived.
That's very true.
So then what happens when you said we can't go into this election without a constitutional amendment? There is a matter now before court. There is a parliament going into recess. Where is the time to do all of this?
Sorry, which matter are you referring to, which is before court?
There's contempt of court. You can't continue dealing with that matter which has already been...
Oh no, that matter, even Pastor, that's a non-starter. It has no legs. I've just demonstrated to you.
No, but if
it has no legs, those are just politics.
Okay, but if it is active, the committee cannot be sitting on a matter that is being tabled before the court. That's the question I'm trying to bring to you. How do you have a committee sitting over a same matter that has been taken to court?
I don't know what will happen, but what I can safely tell you is that that contempt of court is an abuse of court process, and I'm very sure that it might be dismissed because it is a proper abuse of court process.
One last question from me before I pick up calls from our viewers. Submission of people's views and the report from the Mshavati plus the draft bill 7 does not constitute this bill going through. What if it falls on the floor of the House? Then what happens to you saying, no, we'll be against the Constitution if we go into an election without passing this Constitutional amendment? If it falls on the floor of the House?
If it falls, at least the caring government would have done its best. You understand? Because it's not like the government wants it at all material costs. No. The caring government would have done its part. That's why at the end of the day, it's subjected to a vote of majoritarian vote of 2/3 at second reading and third reading. It would have done its part. However, that will not stop the constitutional crisis that we are going to have without delimitation. We are going to have that constitutional crisis.
Right.
So at that particular point,
let's pick up a few phone calls from our viewers. Good evening. Welcome to State of the Nation. Your name and where you're calling us from.
My name is Loti. My name is Loti Upaka.
Loti?
My name is Loti Upaka, yes.
Okay.
I'm calling you from Chisamba.
Yes, Mr. Upaka.
I have a challenge with the person you're interviewing. They're not responding to questions and they're putting you in a position as if they're the ones interviewing you. That's a challenge that I have. He's not responding to specific questions you're asking him. Can you respond to the questions that you've asked him and like the way he's behaving like he's interviewing you?
Like which question, Mr. Loti?
You earlier asked him that you cannot present two things in Parliament, and he has not responded to that.
All right. I think he has taken note of that. I think he'll be able to address it. So you can feel free to call. We need to get the views of the people, like the Mshavati report on this constitutional making process. The gentleman from Chisamba says you are being sketchy in terms of responding, and particularly that you can't have two bills on the floor of the House. Let's pick up this phone call and then you answer them together. Good evening and welcome to State of the Nation. Your name and where you're calling us from.
My name is Aaron. I'm calling.
Oh, Aaron, we lost you. We lost you there. So, there is Bill 7 and there is the Mshavati bill.
So, to be very clear, there are no two bills that are on the floor of the House on the same subject matter. So the bill that is on the floor of the House is Bill 7. Bill 7 has followed the safeguards that are provided for in Article 79. What are those safeguards? It was gazetted 30 days before it was placed in the House. What happened after the directive from the Constitutional Court to consult the people? Bill 7 was merely deferred and not withdrawn. So the bill that is on the floor of the House is Bill 7. That is the only bill that is on the floor of the House. The Mshavati draft bill, together with the technical report, will go to the select committee. It will be used as resource material in scrutinizing Bill further scrutinizing Bill 7.
Right.
Just like all other submissions that we are going to give, or citizens or organizations are going to give the parliamentary select committee, all those are going to be used to scrutinize the bill, and will be a basis. It will be a basis for debate in parliament. Now,
20 million Zambian people. The Mushavati exercise only managed to capture 11,860 submissions. And that represents perhaps less than 1% of the Zambian population. And the majority Zambians are saying, we still feel unconsulted. Remember, the Mushavati didn't go to districts. They only went to provincial centers. If you say there was online submission, people in the rurals don't have access to internet. There is load shedding, hardly people having access mostly to these facilities. Why would it be so? Because we are saying this administration is not desperate, but it does come across as being very desperate. First of all, the time within which the Mushavati constitutional submissions was made was in about 15 to 12 days or thereabout. That's very limiting. And people have said, we are not opposed to a constitutional amendment, but the time is too short. Can we not maybe continue with the submissions? And then after the election, the report could be consolidated, given that the UPND is very confident of returning to power. They say they don't have an opposition. They can come and pick it up after inauguration.
I do, first and foremost, I do not think that UPND has said that there is no opposition.
Oh no, they have said.
No.
On several times,
no.
on several occasions.
See, what is there, even you know that what we have is a confusion of opposition. That is not to say that there is no opposition. There is opposition.
I am telling you what is on record.
Anyway, coming to these views. So you've said that 11,000 submissions show a desperation. Isn't it?
It's a drop in the ocean. It doesn't represent 20 million.
In 2016, when the amendment was done to the Constitution, how many submissions did we have? From the 18 million then, we had the 13,000. These 13,000 were collected in a period of 2 to 3 years. 13,000. This government, the Mushavati Technical Committee, within 12 to 15 days, they garnered 11,000 plus. You see, this does not show desperation. Well, actually, what shows desperation is these who amended the Constitution in 2016. Because even after going to people for 2 to 3 years, they still just got 13,000. This was desperation.
The time frame was sufficient.
The time frame was sufficient, but the people did not submit. What do you want government to do? To go and force people, go and submit. Go and give this submission. You can't force people, unfortunately. And in looking at 20 million, you also need to remove kids.
But
no, just wait.
A minute.
We are not looking at 20 million.
I think let's get this context right.
Yes.
It is the people who should demand for a constitutional change. It is not. It's not the executive that should demand for the constitution to change. It must be people driven. Even the spirit you were talking about. So you cannot say this government. No. Let's depoliticize this constitutional making process. It's about the people.
That's very true, Pastor. And I agree with you that the demand should come from the people.
And the people are saying, can you
look at Article 5 of the Constitution? Article 5 of the Constitution tells you that the sovereign power comes from the people. It can be exercised directly or indirectly. Directly by the people through a referendum. indirectly through their representatives. The executive, whenever it acts, it is using the indirect power that it gets from the people.
Don't you think that there's a notion?
These constitutional amendments are not pushed by the executive. There is no one in the executive who is going to tell you that we are the ones, or the president is the one who is pushing these amendments. These areas came from court decisions. Some of them came from for example, the issue of delimitation, it came from the Constitution. It is the call by the people that our constituencies are too big. So only a responsible government can take up that challenge and say, oh, we've heard the cries of the people. Women, people with disabilities and youths have been crying to be part of the guaranteed table of governance. It's not the executive that wanted. It is the people of Zambia.
And the people,
through their representative.
And the people of Zambia are saying...
Which people of Zambia? Because we have two views right now. We have two views. We have those who are saying, we want this. And we have those who are saying, we do not want this. So it is a government that descends. You need to descend as a leader. These cries from the women, youths, and people with disabilities started in the 90s. They want a guaranteed seat. They do not want discretionary powers, where today I just decide, okay, I'm going to appoint Zaza Maqueen because he's disabled. No. Or is with disabilities. No. They want to have a clear seat at the table. So this is not coming from President Hakainde Hichilema or his executive. It's from the people. They are just carrying the views of the people. That's why if this bill is defeated in Parliament, they will not cry, or the government will not cry. At least it would have done what a responsible government should have done.
Right. So as we are coming to the end of this discussion, what would be your word of advice? As you have said, there are those who are saying we shouldn't go ahead, and there are those who are saying we should go ahead. And this seems to have created such a rift in the nation. Constitutional making should not create so much tension. It must actually bring people together. A dissenting government, what should it do in a situation like this? That the constitution must be amended at all costs, even when the country seems to be so divided?
I think it is not the wish or the desire of government to amend the constitution at all material cost. No. The government is only carrying the mandate of the people from where it got its power. So it is carrying that mandate of people who are saying, let us give us a guaranteed seat at the table. And this constituent of people who are supporting the amendment, you've seen that they're even more louder than those who are not supporting. Those who are not supporting, they are not talking about Bill 7, the challenges that are in Bill 7. I'm glad that Madam Betty Kateva has even said Bill 7 is okay. Sorry, Beauty Kateva has said Bill 7 is okay. The only problem I have, what she said is, Bill 7 is okay. The only problem she has is that it's the process. You understand? So even if he had gone to State House and said, oh, Mr. President, me, the problem I have with Bill 7 is that it's a good law. But the problem is the process. How can we harmonize going forward, and how can we make this workable? That's what dialogue is about. It's give and take. But what did they go and do? They go to the president, they start talking about promises. That was a missed opportunity to genuine dialogue. Because we need genuine dialogue. Yes. So going forward as a country, let's not politicize things. Let's look at the content. Is this going to enhance the betterment of the people of Zambia? I hold the view that Bill 7 will enhance the betterment of the people of Zambia. We are not going to have an unnecessary by-election, which is a cost to the nation. You see, we are going to have, if it passes, we are going to have a number of constituencies, meaning more money to the people and more development to the people. Then the next stage is we now need to come up with the economic and social rights. So in those economic and social rights now is to make sure that government provides a platform for its people. Water, clean water, education, health facility. For now, the government is working on those things. Then they'll come up with the economic, social, and cultural rights.
Maqueen Zaza, constitutional lawyer.
Thank you so much.
Thank you for coming to State of the Nation. And we have been discussing the constitutional amendment, a saga or a necessity. I would like to believe that you have picked the submission of my guest. Until next time, the Lord bless you and keep you.